Hello, Namaskar. Today we are going to discuss on the topic contingent contract. Before entering into this topic, let me tell you a couple of points regarding contract. So, contract simply is an agreement that is enforceable by law. Now, we have to understand what the agreement is. All contract are agreement, but all agreement are not necessarily contract. Why all agreement are not necessarily contract? Because we have already discussed that agreement enforceable by law is only contract. Then we have to understand what agreement is. Set of promise along with some considerations becomes agreement. Set of promise. Set of promise means offer and acceptance. Offer by offerer and acceptance by the acceptor. If there is offer and acceptance, then it becomes set of promise. Set of promise along with some considerations becomes agreement. Agreement, if it is enforceable by law, then it becomes contract. There are 10 essential elements of a valid contract. They are: there must be two or more than two parties in a contract, or there must be plurality in the parties. There must be offer and acceptance, lawful consideration, that means something in written between the parties. What is the benefit to both party and what is the detriment to both party is very important. Consideration means something in written between the parties is called as consideration. The object of the contract or the purpose of the contract must be lawful. Another essential element is the capacity of party. That means the parties must not be minor. That means the parties must not be below 18 years. Insane, the party must not be person of unsound mind, and the parties must not be disqualified by laws. Another is contractual intention of parties. That means the parties must have the contractual intention, and the consent of the parties must be free. That means there should not be any coercion, undue influence, fraud, misrepresentation, and mistake while doing the contract. And another essential element is it must not be expressly declared void by laws. For example, it should not be contract like restraining someone to do trade business and or practice any profession, or it should not be like contract restraining someone to do marriage. Such kind of contract are void, or such kind of agreement are void. Another essential elements of valid contract is it must be certain and possible to perform. I would like to stress on this point: certainty and possibility of performance is very important in a valid contract. So regarding this point, we shall be discussing in the contingent contract also, and another is legal formalities in the contract. So the National Civil Code 2017-2074 has already discussed or has stated that contract can be oral, written, or it can be oral or written, or it can be created by the conduct of the parties. But there are some conditions for certain kind of contract. That must be in the written form, or that must be registered. So we shall be discussing this in another chapter, but in today's chapter we shall be discussing on the topic contingent contract. Contingent contract In Nepali, it means samyogik karar. Samyogik karar. Contingent contract means a conditional contract or the contract which depend upon an uncertain future event or a contingent event. The word contingent is derived from the Latin word contingentem, meaning depending upon circumstance. The general rule of contract is there should not be any condition attached in the contract for its fulfillment. But contingent contract is the exception to this general rule. A contingent contract is called a conditional contract, meaning the happening or non-happening of the contract depends upon an uncertain future event. Having some consideration is the basis of the contract, and without the occurrence of such attached conditions, no liabilities of the parties is created. There are some features of contingent contract. Contingent contract, as I already told you, it's a valid contract. It's exception to the general contract. It states about what to do or what not to do in future course of action. It is future action or future contract. The contingent contract is possible to perform, but it is of uncertain nature. The event of contingent contract must be collateral to the subject matter of the contract. The parties to a contract or in contingent contract must perform their duty if the imposed condition is met. So the example of the contingent contract are all types of insurance, indemnity and guarantee contract are considered as contingent contract. There are differences regarding ordinary contract and contingent contract. Ordinary contract is generally performed as soon as it is signed, whereas contingent contract is performed in the future. And one of the essential elements of a valid contract or the ordinary contract is it must be certain and possible to perform, whereas contingent contract is possible to perform but it depends upon the future uncertain event. So we have to focus or we have to remember this point, future uncertain event. And the parties might get the consideration in present or future in the ordinary contingent or ordinary contract, whereas in case of contingent contract the parties get the consideration in the future. There are the rules regarding the contingent contract. Generally there are 5 rules that is given in our National Civil Code 2017-2074. So it has given the 5 rules and we shall be discussing 5 rules along with one another rules that is prevailing in India. So we shall be discussing 5 rules. So the very first rule is contingent contract. In contingent contract, the rule is it depends upon the happening of an uncertain future event. On the happening of an uncertain future event. This means the very first rule of contingent contract is it is said to have been concluded on the happening of an uncertain future event. That means if a contract is concluded to do or not to do any work regarding the happening of any event in the future, the contract does not create any liability until such event take place. So let me give you example, and with this example you can be clear. The parties did the contract, the fire insurance of the house with the insurance company. Here the parties did the fire insurance of the house with the insurance company. Now, until and unless the house gets caught by the fire, such liability does not arise to the insurance company. So let me tell you, or let me give you in Nepali, भविष्यमा कुनै घटना घटेमा कुनै काम गर्ने वा नगर्ने गरी करार भएकोमा त्यस्तो घटना नघटेसम्म त्यस्तो करारबाट कुनै दायित्व सिर्जना हुने छैन. That means until and unless the house gets caught by the fire, such liability does not arise to the insurance company. So this is the very first rule of the contingent contract. The second rule is on the non-happening of an uncertain future event. That means if a contract is so concluded as contingent contract, such a contract shall not create or shall create no obligation if that person does anything by which he or she becomes unable or it becomes impossible for him or her to do such an act. That means भविष्यमा कुनै अनिश्चित घटना नघटेमा कुनै काम गर्ने वा नगर्ने गरी करार भएकोमा त्यस्तो घटना घट्न असम्भव भएपछि मात्र त्यस्तो करार बमोजिमको दायित्व सिर्जना हुनेछ. Let me give you example and then you can be clear with the example. For example, the parties can do a contract for the cultivation of crops and the condition could be if rainfall does not occur, then only there could be the cultivation. So what is the condition here? If rainfall does not occur, then only there could be the cultivation. On the non-happening of an future, uncertain future event, that means not happening. If rainfall does not occur, then only there could be the cultivation. They will do the work, they will do the cultivation. When they will do? If rainfall does not occur, then only they will do the cultivation. So this is also the second rule of the contingent contract. Third rule is on the event linked with human conduct. That means भविष्यमा कुनै व्यक्तिले कुनै खास काम गरेमा करार भएको मानिने गरी करार भएकोमा त्यस्तो व्यक्तिले त्यस्तो काम नगर्ने वा गर्न नसक्ने गरी कुनै काम कारबाही गरेमा त्यस्तो करारबाट कुनै दायित्व सिर्जना हुने छैन. So the next another rule of the contingent contract is if a contract is concluded to do or not to do any act, and if any uncertain event does not happen in the future, the obligation under such a contract arise only after such an event become impossible to happen. So with this only, this is with this the contingent contract arises. Another rule is on the event happening within a fixed time. That means if a contract is concluded to do or not to do any act, if any event happen within any fixed time in the future, the contract is considered being void after such an event become impossible to perform within or after the expiry of the certain fixed period of time. That means, let me give you example. If A did contract with B to buy the tickets of the movie for certain date, okay, but if the movie is not released on certain fixed date, then such contract may not be valid. So if you do the contract with the condition of on the event happening within a fixed period of time. So here it is stated in section 513 of National Civil Code, where it has stated that भविष्यमा कुनै निश्चित समयभित्र कुनै घटना घटेमा कुनै काम गर्ने वा नगर्ने गरी करार भएकोमा त्यसरी निर्धारित समयभित्रै वा निर्धारित समय समाप्त भएपछि त्यस्तो घटना घट्न असम्भव भएपछि त्यस्तो करार बदर भएको मानिनेछ. So if that could not happen on the fixed period of time, then the contract becomes the void. So if you do the contract could be like this. Okay, I will do the work if rainfall occur within this time, then only I will do this work. So that might be the condition. So if rainfall occur within this time or within this date, then I will do. After that, I have to go somewhere or outside the country. So you might have that condition. With that condition also, you might do, or you might be in the contract with the another party. The rule is on the non-happening of an event within a fixed period of time. So similarly, all the rule of the contingent contract is, if a contract is concluded to do or not to do any act, if an event does not happen within any fixed time in the future, the obligation under such a contract should arise if such an event does not happen, or it becomes certain that such an event will not happen within the fixed period of time. Means you did a contract. What is the condition? The condition is on the non-happening of an event within a fixed period of time. That means if you have the contract condition is, I will do the contract or I will fulfill this if it does not happen within the certain fixed period of time, then only I will be doing this work. So it might be your condition. This might be the rule for the contingent contract. Here what you have to understand is, so sometimes the parties might have the condition. The condition might be the happening of some event within the period of time, or not happening of an event within the fixed period of time. For example, in case of insurance policy, you might have brought the insurance policy that within 1 year time, if your scooter gets some damage, then the company will pay you or indemnify you. So if it does not happen within the fixed period of time, then the insurance company is not obliged to pay you the amount. So this kind of contract might be there. The contract might be there with the condition. The condition may be with the happening of some event within the fixed period of time, not happening of a certain event within the fixed period of time. If the event happened within the fixed period of time, if you cultivate your crops and if I get the fruits of your crops within this period of time, then I will buy. So that might be the condition. Or if your goods get damaged within this period of time, for 1 year of time, then I shall be obliged to pay you or indemnify you. So that might be the condition. So this kind of contract is also considered as a contract, and the name for that kind of contract is the contingent contract. Another kind of contract is contract contingent on an impossible event. So the National Civil Code 2017-2074 has not dealt about this part, but Indian Contract Act 1872 under section 36 has specified the rule that if a contract or if a contingent contract is based on the happening or non-happening of an impossible event, then such a contract is void. So let me give you example what it tries to say. Human beings are mortal. This is the statement. So this is the proposition. If A did contract with B to pay 10 lakh rupees in cash, B lives forever. So this contract is not valid contract. Instead, it is void contract because the aforementioned statement is universal fact that and thus cannot be revoked. So all human beings are mortal. That is what? That is the statement which is the universal fact. So that kind of contract cannot be the contract. So that kind of condition cannot be there in the contract. So what we have to understand is contingent contract simply is the conditional contract. So it depends upon the future event, future uncertain event. So we have discussed the rule regarding the contingent contract. Now we are going to discuss the difference between the contingent contract and wagering. Is wagering similar to contingent contract or it is different? So we shall be discussing here. As I already told that contingent means something which is linked with an uncertain future event. But wagering simply means bet, where two people do wager based on the future uncertainty that is mutually agreed by the party. So here wagering is the bet, and what do the people do? People do wager because of future uncertainty that is mutually agreed by them. Here contingent contract is a type of contract that is said or stated in the National Civil Code 2017-2074, whereas wagering is never a contract. So the National Penal Code 2017-2074 states that wagering is not a contract, rather there is punishment for the wagering. So if we see the definition of the contingent contract, here contingent contract simply is the contract to do or not to do something if some event collateral to such contract does or does not happen. So it has the wider scope, whereas wager is a promise to pay money or money's worth on happening or non-happening of an future of an uncertain event. So the applicable, if we see the wagering, then section 125 of the National Penal Code 2017-2074, it has stated that no one can bet or cause betting. A person who so bets that he or she will receive or lose any movable, immovable property or consideration if any particular party wins or loses any game or process that can be played or caused to be played is considered to have committed the offense of betting. That means here one party win, another party lose in the wagering. That means there is the concept of I win or you win in the wagering, whereas in contingent contract there is the concept of I win or you win. Now the liability in the wagering is unilateral or to only one party, whereas the liability in the contingent contract is reciprocal. That means both the party receive something, there is benefit for the both parties and there might be detriment to the both parties in the contingent contract. The purpose of the wagering is winning the game. But regarding the contingent contract, the purpose might be of doing the business. Here contingent contract is void contract, so we cannot compare this void contract with the contingent contract, because contingent is enforceable and it is valid, as I already told, whereas wagering is void contract, and wagering is void or it is null, and it is also punishable. So if somebody is found doing wagering or playing, then he or she shall be punished. So it is stated in the National Penal Code also, whereas contingent contract is permitted. For example, A and B plays with the card. A agrees to pay B RS, for example, rupees 2000 if A got the card with number K. Then playing card itself is a wagering. So wagering is not permitted in Nepal. In a wagering agreement, there is no independent interest apart from the money to be won or lost. So there is no such kind of interest of the parties. And here wagering contract is, or wagering is a game losing or game gaining, and also gaining matters. So here what happened is, so wagering is a game, and there is win and lose of one parties to the wagering. So as it is clearly stated that the law has made it as punishable also. There is one case regarding this gambling. So it is the case of 2063, decision number 7774, Rajendra Dhakal versus Bhai Raja Pradhan and others. So let me give you the fact of the case. Here the police arrested 10 people when found gambling in two groups along with house owner Bhai Raja Pradhan. Police confiscated the amount of cash 53,128 rupees and other things like card, wool, carpet, mat, emergency light and table. On the same day, Police Inspector Rajendra Dhakal presented the file, the first case report stating the thing about things found in the scene. The case was filed in the District Court of Morang. So here now the legal issues in the case was the game of cards called marriage fall under gambling or not. So there was the question, there is one game in the card that is marriage, so it falls under the gambling or not. And the another legal issue is the accused has committed the crime or not. Here the court held the game of card called marriage falls under gambling, as gambling is the game of chance which is played upon lying or wager for gaining or losing money. So in marriage game there is a set rule, and upon happening of certain event, the party either loses or win. Also the player were playing with their consent. Thus the court concluded marriage falls under gambling, which is illegal. So the marriage game is the gambling. And the court held that the accused has not committed the crime. So from the fact, the court came to the conclusion that the accused was sick and his relative came to visit him. The witness denied the fact that the money belonged to the accused. So here the court has defined or said that the marriage game within the card falls under the category of gambling, but the accused has not committed, but declare that the accused has not committed the crime. So we were discussing whether the gambling falls under the category of the contingent contract or not. As we are clear that the gambling or betting is prohibited by law, it is not similar to contingent contract. Contingent contract is a valid contract, and it is stated as the valid contract in the National Civil Code in section 513, whereas the gambling or betting is prohibited and it is considered as punishable, so it is stated in the National Penal Code 2017-2074. So here I told that the general rule is gambling or betting is prohibited by law, but there are exceptions to this. The following does not fall under the category of gambling. Which does not fall under the category of gambling? It falls, but there is no punishment, or game so played with the approval of government of Nepal. That means if the game is played with the approval of government of Nepal for entertainment in a public ceremony, fair, festival, exhibition or event, that a small amount of movable property is won or lost. So in that case, there is no punishment, and a lottery operated with the approval of the authorized authority. In that case also, there is no punishment. So regarding the punishment and fine of the contingent of the gambling or betting, if a person is found of playing gambling, then he or she is liable to the sentence. They are as follow. For example, imprisonment for a term not exceeding 3 months or a fine not exceeding 30,000 rupees in the case of one who gambles or causes anyone to gamble for the first time. So if it is the first time, then imprisonment not exceeding 3 months or fine not exceeding 30,000 rupees. And if it is for the another time, imprisonment for a term not exceeding 1 year and a fine not exceeding 50,000 rupees in the case of one who gambles or causes anyone to gamble for the second time. And if it is third time, fourth time, then additional sentence of imprisonment for a term not exceeding 3 months and a fine not exceeding 10,000 rupees for every subsequent offense. So it increases along with the time. And another important thing here in the gambling is in regard to punishment and fine is all instruments which are found in gambling, movable property or movable things, they are taken. So if you cannot claim that we were just playing, so the things, the movable things which can be transported, they are also taken. And another thing is we have to understand that no person can bet or cause betting. So generally we do in the time of football and other, so we bet, that is also not permitted. So betting is also prohibited, or it is also punishable in context to Nepal. So gambling, you cannot do gambling. If a person who so bets that he or she will receive or lose any movable, immovable property or consideration if any particular party win or lose any game or process that can be played or caused to be played, under law is considered to have committed the offense of betting. That means if a person take the sides of any game, or if a person win or lose, then he or she has committed or is imagine that he or she has committed the betting. So betting is also prohibited. Now at last, what we have to understand in contingent contract is the general rule of contract is all the essential elements of a valid contract must be present, but sometimes the one of the essential elements of a valid contract. That means certainty might not be in contract, or there might be the condition in the contract. If the contract is with the condition, then the contract, such kind of contract, is called as contingent contract. That means a conditional contract, and it depends upon an uncertain future event. So some contract which depend on the uncertain future event, then that kind of contract is known as contingent contract. So what we have to understand is there are different kinds of contract, like unilateral contract, which is considered as one-sided contract, like indirect contract or quasi-contract, where there is no consensus ad idem, that means meeting of the mind of the parties to the contract. Like that, there might be the contract with the condition. So the contract with the condition is considered as the contingent contract, and it is recognized as a contract with the name contingent contract in the National Civil Code.